Good morning. Good morning. A very new trend judgment in respect of Domestic Violence Act. Supreme Court has delivered it. Very important judgment. Those who all are conducting and defending Domestic Violence Act must keep this judgment on file and record. This is AR 2022 Supreme Court 2331. Prabha Tyagi vs. Kamlesh Devi. It's a cause title. Before going to that, you must know the history of the case. Then only you can understand the importance of this judgment. Aggrieved person, Prabha Tyagi married Kuldeep Tyagi, son of Vishnudat Tyagi. Marriage was 18/6/2005, Uttarakhand, Haridwar district. Thereafter, she seems to have given dowry, and then they started living at ancestral home of the respondents with her mother-in-law, respondent, two brother-in-law, and brother-in-law's wife. Then, thereafter, she started living with her husband at village Jabreda. Kuldeep Tyagi husband died on 15th July 2000 in a road accident, car accident. After the ceremony, she was forced to reside at Delhi. So then she conceived a child also, and a child born daughter, and thereafter she seems to have meted out to misbehavior and torture by their in-laws. So she moved to Dehradun, Uttarakhand with her dad, and for her support she engaged herself in some job, teacher job. Then she seems to have this Maruti car was given to husband by as a Sridhana, and our mother-in-law seems to have objected that insurance amount should be paid to mother-in-law. Then they even claimed that the child was not born to her husband, Tyagi. She filed an application to Section 12 for protection order, residence order, compensation order. The lower court, the land magistrate, seems to have granted 10,000 rupees per month as monetary compensation, 10,000 compensation for maligning and aggrieved person, and article of Sridhana should be directed to be written except Maruti car, and the respondent shall not obstruct the aggrieved person and the daughter from enjoying the property of Kuldeep Tyagi. This was the case. The finding of the court. Now, important thing was appellate court set aside the judgment on certain reasons that we will look into. Thereafter, she went to High Court. High Court also dismissed. Now, the point for consideration. This is all are the three questions framed before the Supreme Court. Whether the consideration of domestic incident report is mandatory before initiating proceedings under DV Act, or in order to invoke substantive provision of Section 18 to 20 and 22 of the Act. They say protection officer report is mandatory. Whether it is mandatory for aggrieved person to reside with those persons against whom allegations have been levelled at the point of commission of violence. Then whether there should be subsisting domestic relationship between the aggrieved person and the person against whom relief is claimed. These all are the questions framed. Now, before going through the finality of judgment, now I will read headlines. That is most important. Headlines: domestic incident report. Where no report is received by magistrate, he would naturally not consider report before passing an order on the application. That was they say. The word shall used in the proviso is restricted to only those cases where protection officer files domestic report. When if he does not file, the magistrate need not, that shall will not apply. Then they say, residence, it is not mandatory for aggrieved person to reside with those against whom allegations have been levelled. Aggrieved person has right to live in share household, her matrimonial home, and being a victim of domestic violence could enforce a right to live or reside in share household under provision of the court. Then next index, protection of application by aggrieved person under section 12. It is not necessary that at the time of filing application domestic relations should be subsisting. Then they say when they are related by consanguinity, marriage, relationship in the nature of marriage, adoption, or family members living together as joint family. So after discussing all this, they held that the death of her husband does not prevent her from filing this petition. Then I will take you the last paragraph of the judgment. They say, in view of the discussion, the three questions raised in this appeal are answered. The first question number, whether the report is necessary. Section 12 does not make it mandatory for a magistrate to consider a domestic incident report filed by the protection officer or service provider before passing any order under DV Act. It is clarified that even in the absence of domestic incident report, magistrate is empowered to pass both ex parte or interim as well as final order under the provision of DV Act. Then the question number 2, it is not mandatory for the aggrieved person when she is related by consanguinity, marriage, through a relationship in the marriage, adoption, or family members living together as joint family to actually reside with those persons against whom allegations have been levelled at the time of commission of domestic violence. If a woman, this is most important, if a woman has right to reside in the share household under section 17 of the DV Act, and such woman became an aggrieved person or victim of domestic, she can seek relief under the provision of the DV, including enforcement of right to live in a shared household. Then finally they say, subsisting domestic relationship between the aggrieved person and the person against whom relief is claimed, allegation of domestic violence. However, it is not necessary that at the time of filing an application by aggrieved, the domestic relationship should be subsisting. In other words, even if an aggrieved person is not domestic relationship with the respondent in a shared household at the time of filing application under section 12, but has at any point of time lived so or has a right to live, has been subject to domestic violence or is later subject to domestic on account of domestic, entitled to file application. Consequently, they set aside the High Court order as well as Sessions order and uphold the lower court order. So this is most important. What all are the points for consideration? That if she initially started living with the parent in-laws house and subsequently due to some reasonable cause she was not residing there, still she can claim sharehold house of residence. Number 2, that domestic report by protection officer if not filed, the magistrate need not look into. Number 3, when the domestic violence was committed and subsequently committed due to the relationship, marital relationship, still she can file petition under section 12. Therefore, nowadays normally the magistrates hesitate to take cognizance against in-laws, but here in the case they are specifically directed to take cognizance against the in-laws. That apart, even at the time of admitting court proceedings, particularly in Tamil Nadu as well as Bangalore, so far other in-laws are concerned, they normally grant stay and order dispense with of appearance. This should be looked into because protection officers are not properly looked into due to heavy work. So this is a very landmark judgment, Prabhat Tyagi versus Kamlesh Devi, AR 2031 Supreme Court, best judgment. Kindly take. This is judgment 12/5/2022. Very recent judgment. Keep this judgment and go through the entirety of act if you want to substantially argue either way. Best